Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Court of Appeals for the Fifth Circuit. This is the case of April Cadena versus El Paso County. In this case, April had been injured and had a recent surgery. Her doctor advised her that she could not walk even with crutches. However, shortly thereafter, she was arrested, and she was made to walk with crutches. She then hurt herself. The question is this a violation of law? So we're going to see what the court said, and let's get started with this. The El Paso police arrested the defendant on an outstanding warrant for a failure to appear. At the time of the arrest, the defendant was in a wheelchair because she had undergone surgery on her right leg to repair a broken tibia 3 days earlier. She was discharged from the hospital only 24 hours before her arrest, with instructions stating no weight bearing for her right leg, and notes from her physical therapist explaining she'll not be a candidate for crutches and she'll have to be discharged with a wheelchair. Based on the intake procedure, the county's physician, Dr. Salazar, gave telephonic orders that the defendant be given pain medication, that she follow up with an orthopedic physician in 2 weeks, and that she be given crutches, that be assigned a lower bunk, and she be given wound care on the right leg. The defendant testified that after intake, her wheelchair was taken away. She also testified that as she was being led to her cell, she overheard the staff saying there was no space in the county lockup for a person in the wheelchair. So here we're seeing that during the intake, they were interviewed by a physician for the prison or for the county. And the prison intake physician said, no, you can walk on crutches. Despite, your doctor's order said, you'll be fine. Just give her a lower bunk, give her some wound care, but she can walk on crutches. She doesn't need a wheelchair. So that was what the intake physician said as part of the intake procedure. So they took away her wheelchair 3 days after her surgery and 1 day after being discharged. So, okay, that's a thing that happened. Jails actually do have to be ADA compliant, as a matter of fact, and that is part of the basis of the lawsuit. We're going to get to that. The defendant told 2 officers escorting her to the clinic that she could not walk with crutches and she needed a wheelchair. On the way to the clinic, she stumbled while attempting to move using crutches, and the officers had to catch her before she hit the floor. After this, one of the officers who escorted her obtained a wheelchair and wheeled her to the rest of the way to the clinic. At the clinic, the defendant testified that the nurse there told her there was no space on the floor for a wheelchair. Defendant testified that she was left in her cell with only crutches after the clinical visit. 2 days after her arrival, the medical staff entered an order allowing her to keep the wheelchair. At 4:30 p.m. that day, 6 hours later, however, she did not yet have the wheelchair at a mealtime, and she fell in her cell while carrying a tray with food while also using crutches. The defendant was taken to the jail's medical clinic and then the emergency room. The emergency room physician recommended a boot, a non-weight bearing status, and a follow-up appointment with an orthopedic surgeon the next day. After the fall, the defendant reported the pain in her leg as a 7 out of 10. The defendant testified her leg was twisted, with her foot facing the middle of her body, and her medical records confirmed the tibia was malaligned. So because she was ordered to walk with crutches, which her initial physician said she couldn't do, and she was carrying a food tray while doing so, she slipped and fell, and she re-injured her leg to the degree that it was just reported. While residing at the facility, she underwent a second surgery. The medical records from the surgery states that the defendant was in extreme various and extreme pain before the corrective surgery. Even after the second surgery, the defendant alleges that she had continuing nerve damage in her right leg and she cannot engage in recreational activities or ambulate normally. The defendant claims that the El Paso County violated Section 2 of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act by failing to provide her with reasonable accommodations. The defendant also claims that the county was deliberately indifferent to her serious medical needs in violation of the 14th Amendment. She alleges these constitutional violations were a result of the county's unlawful policies, procedures, and customs. So next, the court has to analyze the Americans with Disabilities Act claims, whether they apply to prisons and whether they were violated in this instance. So let's review the ADA complaint. Title II of the Americans with Disabilities Act provides, no qualified individual with a disability shall, by reason of disability, be excluded from participation in or be denied the benefits of the services of programs, or activities of a public entity or be subject to discrimination by an entity. The statute goes on to define public entities to include local governments. And the Supreme Court has held that prisons are public entities. They may not exclude disabled individuals from participation in or deny them benefits of services, programs, and activities. So yes, the local jail does qualify as a place that has to comply with the Americans with Disabilities Act under the Supreme Court precedent and under the relevant case law. To make out a prima facie case under Title II or the Rehabilitation Act, a plaintiff must show that they are a qualified individual within the meaning of the law, that they are being excluded from participation in or being denied the benefits of services, programs, or activities for which the public entity is responsible or otherwise being discriminated against, and that such exclusion, denial of benefits, or discrimination is by reason of the disability. Finally, to recover compensatory damages, a plaintiff must prove the discrimination was intentional. This court has hesitated to delineate the precise contours of the standard for showing intentionality, but the cases to have touched on the issue requiring something more than deliberate indifference, despite most other circuits defining the requirement as equivalent to deliberate indifference. There is no dispute that the defendant was a qualifying individual under the Americans with Disabilities Act, and the disabled inmate's right to mobility within a prison is well established. Smucker 1986 says deliberate indifference isn't enough. Not in this circuit, it's not. We need a little bit more. So yes, that's the case law. Deliberate indifference is not enough. You need even more than that. This is your continuing reminder that I'm just the messenger. So I'm just telling you what it is, not that it's good. The defendant repeatedly requested various types. If I think it's good or bad, I obviously tell you if I think it's good or bad, if I have an opinion. Like, I do that fairly often. Or if I, say this sucks or whatever. So it's like, yeah. If I have a strong opinion, I'll usually tell you what I think. For the record, I think this is pretty shitty. I think, I've said before that I think the 1983 qualified immunity doctrine needs refiguring. I don't really like the way that the law is written, that it's so narrow. Now, I don't know if it should be abolished completely, if qualified immunity should be abolished completely. Probably not. If I as a judge could find a more narrow way or a way of constraining it more without killing it completely, I'd probably try to do that. If there's something I can do to make it not suck as much, that would be my first instinct. Can I make it not suck before I kill this completely? Let's see. The defendant repeatedly requested various types of accommodation and her disability was open and obvious. Therefore, the county was obligated to provide the defendant with reasonable accommodations that allowed her to access its services. The defendant has pointed to several different types of requests that the county has denied. A reasonable jury could find that some or all of the requests were reasonable, and the county violated the Americans with Disabilities Act by refusing to accommodate the defendant. Providing an individual with broken leg with crutches may be a reasonable accommodation with most individuals with this particular kind of disability. But here, a jury could find that crutches did not provide the defendant with meaningful access to the county's services, in part because she could not safely walk within the facility on crutches. The defendant testified she could not walk with crutches, and she informed the staff that she needed a wheelchair at least 3 times. Although a closer question, a jury could also reasonably determine that a county's refusal to accommodate the defendant constituted intentional discrimination. The defendant was admitted in a wheelchair, which she contended was taken away by the jail staff. A few hours later, she attempted to walk on crutches in the presence of 2 employees and was unable to do so. The record shows that the employees were aware the crutches were unsafe because they obtained a wheelchair and they wheeled the defendant the rest of the way to the clinic. And 2 days later, the county medical staff agreed the defendant required a wheelchair. Further, the defendant testified that once at the clinic, she requested a wheelchair, but the nurse who saw her denied the request because the facility did not have space for a person in a wheelchair. Finally, the same employee who had seen the defendant fall while using crutches 2 days earlier than required defendant not only not use crutches, but to carry a tray on the crutches in order to eat. So basically here pointing out that they give repeat notice, they had actual knowledge from the previous thing that she needed a wheelchair and still were denying her and making her do this intense balancing act. And so that was potentially a discrimination under the Americans with Disabilities Act. Yeah, I'm with you, Ewan. I'm with you on we need reform on qualified immunity. I don't know exactly what that means exactly. I don't know exactly what reform we need. You know, if I were having to actually decide it, I'd ask for a briefing on it. What can I do? Get some amicus briefs, and then I go read them and figure out from the many people saying, okay, I want to fix this problem. Here's the problem. How can I fix it? I don't know. Tell me what to do. I go read the amicus briefs and then form an opinion. That's what judges. That's what everyone who's smart should do. Everyone who's smart should say, I recognize my own limitations and I don't know how to solve this problem, but maybe if I ask a lot of other people, they'll help me figure out a way to solve this problem. Hey, other people, I'd like to not be stupid. So what I'd like you to do is I'd like you to tell me all the ways I might fix this problem. And then with your knowledge combined, I will not be stupid and I'll be able to fix a solution, hopefully, that will also not be stupid. So, some humility at your own limitations is always a plus. The defendant has shown a material dispute as to whether the county denied her reasonable accommodation in violation of the law. Accordingly, we reverse the district court's grant of summary judgment as to the claim under the Americans with Disabilities Act. So even though the district court denied the complaint under the Americans with Disabilities Act, the court here is saying, no, there's enough for a jury to find a violation of the Americans with Disabilities Act, so let it go back to a jury. There's a specific statute in play. Of course, there's also the potential 1983 violation. So, is there a 1983 cause of action in addition to the American with Disabilities Act complaint? Let's read more. As a pretrial detainee contesting the conditions of her confinement, the defendant's 1983 claim invokes the protections of the 14th Amendment. For conditions of confinement claim, the proper inquiry is whether those conditions amount to punishment of the detainee. To prevail on a claim of unconstitutional conditions of confinement, a plaintiff must show a rule or restrictions or the existence of an identifiable intended condition or practice, or that the jail official's acts or omissions were sufficiently extended or pervasive, which was not reasonably related to a legitimate government objective and which caused the violation of the inmate's constitutional rights. The defendant has not put forth evidence that creates a material dispute of fact as to whether she was subjected to unconstitutional conditions of confinement. She points to the county's use of the officials to perform the medical intake procedures, its policy of making medical matters the sole province of the treating physician, its requirement that inmates on crutches carry their food tray back to their cells, its failure to provide prompt medical care for non-medical reasons, and its decision to use a single preferred provider for outside medical services. However, the defendant has not shown the jury could have found that any of these practices amount to an unconstitutional condition of confinement. So despite all the massive suck that this is, you can't show that it's cruel and unusual punishment within the meaning of the Eighth Amendment. So this is not enough to show it's an unconditional condition of confinement. So being forced to hobble around on crutches, carrying your tray, totally okay, I suppose. Let's read on. The defendant has also not put forth evidence that these conditions were sufficiently extended or pervasive. She has identified only one other instance in which an inmate on crutches was allegedly required to carry a food tray, and only 3 other instances in which inmates filed grievances alleging delayed medical care. A few isolated incidents do not amount to a condition of confinement. So that is the end of the case in April Cadena versus El Paso County. In this case, we learned that April was arrested shortly after a surgery for a broken leg bone. And although she was directed by her physician not to put any weight on it, a mere 24 hours after discharge, she was forced to do so by a county that arrested her. And she's complaining under both the Americans with Disabilities Act and for a 1983 violation. As to the Americans with Disabilities Act, we have learned that the Americans with Disabilities Act does apply to local governments, and it does apply to prisons and jail facilities. And we've learned that based on the facts as presented, there is enough for a jury to conclude potentially that there's a violation of the Americans with Disabilities Act, so a jury will be asked to that question. As to 1983 violation, she cannot show it was routine practice of the government to engage in this behavior, and so it's not clearly established. There is qualified immunity and no 1983 violation here. And so we'll have to see if she can get any relief under the American with Disabilities Act, despite having a fractured leg, being forced to walk and carry a tray and hobble along, and breaking her leg once again due to this, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.